before we kind of begin on this hearing, I did want to let the court know at around 2:30 our time, which is in about an hour, I'm gonna have to step away for a little bit, so I just wanted to warn the court.
You've got two able-bodied individuals, so I'm not worried about y'all at all. But that's no problem. Thank you for letting me know.
Thank you, Judge.
I think Mr. Shelley and Mr. McCarthy are playing hooky.
You know what, Judge? Mr. Shelley just indicated to me that he has yet to find the link, so I'm gonna call him really quick.
I can, well, y'all have it. You can forward it to him, right?
Yes.
Okay. And maybe Mr. McCarthy's having the same problem.
Hello, Judge. I'm touching base with him right now.
Okay. Thank you. I appreciate it.
Are you in New York, Judge, just for vacation or?
Yeah, well, I came up for Thanksgiving, and then I had some friends of mine that were coming up, and they wanted me to stay a little bit longer so we could do stuff in New York. And
Cool.
my daughter lives up here, so
Oh, she does? Okay.
yeah, I try to get up here as much as I can, and I have a free place to stay.
Right? Because it's
But-
expensive.
Well, it is, but you know, I'm a mom, so I cook and I clean. And
Oh,
I
yeah, it never
wash.
ends for us.
No, poor thing. She's at work all day, and then she has an extra job at night, so
She's
on-
tired. Yeah.
Yeah.
Well, that's good. You're a good mom. We
Mhm.
still go at it all the time, even with our
It
grandchildren.
doesn't matter how old they get.
Right,
I
right.
remember my dad would come and visit me, and he would go and work in the yard all day.
Yeah, isn't that something?
Yeah, and I would just think, why are you doing that, Dad? But thank you. I never complained to him, right?
I think I'd rather want to stay active anyway.
No, it's, you know what, yeah, I think I enjoy it, and they enjoy it. You enjoy coming in and doing those things for your kids.
That's good, Judge.
It's fun. It's fine. But yeah, I'm going back home next week.
Well, be safe and welcome back to El Paso, Texas.
Thank you. Hey, Mr. Shelley, you were able to find us?
Good afternoon, Just. Yes, I had so many links. I think I got the wrong one. Finally, Josh forwarded to me, but I don't believe Mr. McCarthy has it. Well, since Ms. Dingle has it, he should now.
Yeah, I think they're working on that. And Mr. Avila told me that he's gonna have to cut out after about an hour. And I said, there are two very able-bodied assistants up here, so.
With how complicated this case is, Judge, we don't know.
It's the easy part. I don't know what y'all are complaining about. I'll tell you what the hard part is. If I had to do this on either side, is just trying to understand the science.
Yeah.
That's the difficulty, right? And they say we all went to law school, so we didn't have to do any math or science. Thankfully, I'm a math nerd and a little bit of a science nerd, so I like it. But I know that's not everybody's cup of tea.
Yeah.
The subject matter is fascinating, Judge, and it should fascinate any attorney.
I think it's really, yeah. I think it's really, I love it, but I'm kind of nerdy, so I love that stuff. I don't know what to tell you. I didn't find that out till late in life. I thought I was just a happy party girl, but no, I'm a nerdy, happy party girl. There you go. We're not on the record yet, right?
Nope, I hope not.
I'm always worried about running.
On the record, please don't.
Yeah, don't go spreading rumors about me.
I'll ask for that record to be destroyed.
Yeah, exactly. I'll eat it.
What record?
Exactly. No record.
No record. No record. What? No record. No memory. But anyway,
Happen on Zoom stays on Zoom.
That's true.
so y'all are going to learn my little strategy. I always think so. Let's see what happens this afternoon. That if I put everybody to work on a Friday afternoon, they wrap it up quicker. What do you think?
That's going to depend on Mr. McCarthy. But I am certainly hoping that I have no intention on staying long at all. I had no intention of doing that this morning either. My apologies, Miss North, but
I understand. I know. Well, let's see. I thought her.
But I did streamline my cross significantly, Judge. That, I still had, I didn't think I needed any more, but I had a much longer cross-examination planned. I don't think anybody would have wanted to hear anymore.
Well, I think some of that is, in my view, and I don't know, y'all are the attorneys, so I'm going to say y'all are the experts. This is your case. You know your case better than anybody. Some of that is really for the jury, as opposed to qualifying an expert. Other than the only thing I was thinking about, is the basis for their opinion. So you're looking at the science for the basis of their opinion and to understand the reliability. Obviously, I think most of these individuals are going to be more than likely. I'm assuming. I'm not making a predetermination of the evidence, but they're going to be qualified. And I think hopefully, if they're qualified in the right way, their expertise is going to be relevant and bear on the questions that the jury's going to have before them. I think the issue really, if there is any, is the reliability of the science. And given that it's changed dramatically, probably in the last 15 years, that kind of, and obviously there's still this perception, not only amongst maybe medical doctors, but law enforcement, maybe, at all, and not really understanding the changes because they've happened so fast in the scientific community.
Yeah.
Maybe.
The science and the law, they don't get along sometimes. I got a message from Mr. McCarthy. Did they send a different link? Miss Dingle, I would suggest if you are here, probably Mr. McCarthy doesn't have the link.
Well, I just sent it to him. I know that he's in there with tech right now, so I'll send it to him again. Thank you. Thank you so much, Mr. Shelley.
I can send it to him too.
I'm going to send him. Well, I don't know if it's the right one, so.
I have the right one.
Okay.
Let me do this.
And my understanding from Mr. McCarthy is that he only will have me, Dr. Rios-Torres. He will not have Dr. Saloom this afternoon.
Yeah, that's what I understand. And so maybe, and I think he only has, well, Dr. Saloom and either he said Dr. Morthy or Dr. Ross.
Yes.
And so maybe we'll try to either squeeze them in. I'd like to be able to squeeze them in before Christmas, but if not, we're going to have to do it, around the trial. But I think it's really important for y'all to have those questions and have that information before. If I were an attorney, I want to have these hearings before I start trial in order to prepare. You guys are getting a lot of, I think, valuable information. You've already gone through the trial, so you've had an opportunity to do cross with all of these witnesses, I assume, with the exception of Dr. Radovan, because it was her nurse practitioner. But still, it's still.
I would argue, Judge, that our ability to cross-examine was somewhat curtailed during trial, but that's for another day.
That's water under the bridge. We're starting a clean slate, and we're gonna do a do-over. So. And everybody, I think, I know Mr. McCarthy's not here, y'all have the hearing we set on the motion for continuance. You may not have it yet. You want me to tell you when it is?
Yes, Judge, please.
Okay, hold on. Let me get my calendar. We set the motion for continuance. I don't see that it's gonna be very long. I don't think it should be. It's the 16th on Monday at 1 o'clock. I've got one. I usually don't start things till 1:30, but that's fine. So I guess y'all are gonna have to figure out what position you're gonna take in regards to the continuance.
And Judge, just double checking that is December 16th at 1.
Yeah, that's on my count. Hold on, that's my calendar. My calendar's not reliable. I don't know what to tell you. It's something to do with data in and data out in the operator. Let me look at the emails.
And just that you could be aware, Miss Page and I are set for trial on the 13th this Friday on an aggravated sexual assault in the 346.
Okay, and do you expect that to go?
Yes, with a big asterisk.
Okay. But which court did you tell me? 246?
346.
340.
Just like it's in trial right now, but I mean, I anticipate she will be done by Friday. I think this trial has been going on for about 2 weeks.
Yeah, 1 o'clock on December 16th. I mean, and I'm willing to do it later in the week. I have availability that week, so I know that we were going to file it and probably send y'all a file stamp copy, but I thought you guys, did we send it to you? No, we did send it to y'all.
And we probably get it, yeah.
You probably didn't open it, but it's from Robert Vasquez. But I'm just reminding y'all.
I have the setting for that, Judge. Yes, thank you.
Okay. There you go. What are they trying in the 346 right now, did you say?
I believe it's a continuous sex case, Judge.
And how long, when did they start that?
They started around Thanksgiving. Or before Thanksgiving. They picked the jury, I think, right before Thanksgiving or something around there.
So maybe like a week, well, this is the first week, yeah. Well.
Yeah, because we went trial last week. So we'll see. If it doesn't go, then we certainly will be ready.
All right. No,
And Mr. Avila will be ready anyway.
there you go.
With respect, I was expecting the same comment of able attorney for me but I didn't get it. So you know what? I'm kidding,
Sorry,
Judge.
I'm preoccupied with my grade.
I'm kidding, Judge.
I thought we were talking about you the whole time, Mr. Avila.
No, you know what? He was talking about you too. She was talking about me.
I said Mr. Shelley and Miss Pages were your assistant. I don't know if you heard that.
No way, Judge, really?
I did it, but
Frank.
I winked at the same time.
Frank.
I had my fingers crossed behind my back. Y'all are all co-assistants.
I have been called Mr. Avila's assistant before.
Oh my goodness.
In open court, Judge, it was Frank arrived and it was like, Mr. Avila, your assistant there? And I was all like, no.
Now you ought to ask Edie. Edie and I we were traveling international one time, and my daughter was real young. and they thought she was my nanny. Well,
Edie,
she was dressed like a teenager. I don't know what to tell you.
Wow.
Are you the nanny? And she's all like, wow.
I will ask you that as soon as I see her.
Tell her, are you the nanny? And
Yes.
she'll know it came from me.
Uh,
Yeah. And when we first started trying cases together, the jurors sometimes didn't even believe she had graduated from high school yet.
Really?
Yeah. She still looks so young, and my dad would always call her the teenage lawyer because she looked so young, and she has a real high pitched voice.
Yeah.
Yes.
And so, and just the way she carries herself. So I remember a juror would be like, have you graduated from high school yet? Because we would go talk to the juries afterwards. I mean, I think that's really, even when they don't give you the verdict you want, it's really important to know how they think.
Mm-hmm.
He's the lawyer version of Doogie Howser. I don't know if you're familiar with him. Yeah.
Yeah, and she would get real mad. She didn't appreciate it at all. I thought it was funny. Yeah. Well, she'd stamp her foot and want to be taken seriously.
Yeah. Especially start.
And so she should be, but she was too cute. All right.
Donald McCarthy, Judge.
Hey, Mr. McCarthy. Are you
Beg
ready?
your pardon.
No problem.
Yes, ma'am.
Did you you finally got the link?
We finally did.
Okay.
I have some serious issues. I think I got some serious computer issues.
Okay. And your witness?
And yeah, there will be in a moment. I think you wanted.
Yes, that's right. Let me call. Okay. Yeah, you're right. We wanted to do. I wanted to hear y'all's argument. If you just give me a minute, let me go ahead and call the case. Y'all can announce, and we can do that. Okay. The court calls number 2020-0D06504. The state of Texas versus Rodriguez. May I have announcement of counsel?
Donald McCarthy for the state.
Frank Shelley, Mina Page, and Josh Avila for the public defender for Mr. Rodriguez. Defense is ready, Judge.
Right. And I haven't said this before, but I keep reminding myself to do that because we'll forget. And let the record reflect that the defendant, Mr. Rodriguez, is here and participating. All right. Mr. McCarthy, this is your witness. So.
Thank you. We finished with the witness. The state respectfully submits Dr. Violeta Radinovich as an expert witness in this case in the field of the medical specialty of ophthalmology, and moves the court to qualify her as same.
Okay. Yes. So as far as that witness, we do not argue that she is an ophthalmologist, and she certainly, has some qualification. I believe, however, Judge, the issue here is, and our issue is, whether or not she is qualified to express an opinion regarding causation. She certainly can make a diagnosis, but can she discuss causation, which is the crux of this case? And we believe she cannot. And I will explain why I believe that is the case. Dr. Radinovich, I asked her specifically if she understands general causation and specific causation. And that is a critical aspect, because for her to establish or to be qualified, she has to understand general causation in the context of this case, and whether or not the technique that she applies regarding causation and abusive head trauma applies. And then if she were to qualify as to general causation, and only then could she go to specific causation in this case, which is abusive head trauma causation in this case. She acknowledged she has no knowledge of general causation, and that is a predicate to express an opinion on specific causation. So she doesn't meet that. She has expressed she has no knowledge of methodological reliability. She acknowledged she had insufficient data regarding abusive head trauma literature. She acknowledged she had no knowledge about biomechanic literature regarding abusive head trauma and retinal hemorrhaging. And I'm focusing here just on the fit between abusive head trauma and retinal hemorrhaging. I am not talking about whether or not she can recognize retinal hemorrhage. I'm talking about the cause of the retinal hemorrhage. Time again, I ask her, she has no, as she said, the only knowledge of the medical and scientific literature regarding abusive head trauma in the context of retinal hemorrhage is an AI search she conducted this morning on something called Grok. That does not fulfill the requirement. And I don't know what that service is, frankly, Judge, I've never heard of it. But that does not meet the criteria of being familiar with the literature. And I'm not talking about literature in general. I'm talking about the specific literature, which is the crux of his case. She has not reviewed anything in the last 5 years, she said, regarding that particular issue. In fact, she said she has not testified in 5 years, has not reviewed anything in the last 5 years. As a matter of fact, she complained about it because she didn't have time this morning, because she was called late notice, to review any of that. She established she has no knowledge of the medical literature, the science behind it. She doesn't have an understanding about which technique applies in that very narrow field. She doesn't have any knowledge of the underlying scientific theory and whether or not it's valid. I specifically asked her if she has, she understands and she knows the underlying theory behind the vitreal, the shaking mechanism. She said specifically she doesn't. And that really caused me pause. She has never published on abusive head trauma. And I'm not going to make a big deal of the following, but I will note that she is not a published author with the New England Journal of Medicine. I pulled that article, Judge. She is not an author. She may be a co-investigator, but she is not one of the authors. And the court can look at it. I pull the article. I look at the name of the author. Maybe it was, but the question about that, I think, are relevant. She has not published at all. She has not read anything, and she has not conducted any experiment or reviewed anything. She neither has reviewed any of the data related to this case. She's reviewed a report from the hospital. She has not looked at any of the imaging. She opined, by the way, on subdural hematoma without having seen any of these imaging. The source of her knowledge is unknown. She has not expressed that she has any basis for opinion. She may be well qualified to look at an image and tell you this is retinal hemorrhaging, but she's absolutely not qualified to draw the link between abusive head trauma allegation causing retinal hemorrhaging. And when asked specifically about shortfall as a possible mechanism, alternative mechanism, she acknowledged she has absolutely no knowledge of shortfall literature. There was a long discussion about her training and her experience. And I will point out the court can refer to the 2016 PCAST report, who specifically discuss that issue of training and experience. And it is clear that training and experience, there is, and I will pull it, Judge, so I don't misquote it. The PCAST report, quote, experience is an inadequate foundation for drawing judgment about whether two sets of features could have been produced by or found on different sources. They would have no way of knowing accurately in which case two patterns actually came from different sources. And that's where we are here. She doesn't understand or know anything about shortfall. She doesn't know anything about the mechanics of retinal hemorrhaging related to abusive head trauma. Her experience is not sufficient at all to qualify her. Her training, PCAST continue, is even a weaker foundation because PCAST in 2016 said training is even a weaker foundation. The mere fact an individual has been trained in a method does not mean that the method itself is scientifically valid, nor that the individual is capable of producing a reliable answer when applying the method. And here it's particularly relevant because Dr. Radenovich could not identify a method. She could not explain any of the method. She was not aware of any of the method and the underlying theory behind it. She may be qualified for other things, but as far as causation, which is etiology, and I'll spell it Etiolojy, which is very different from diagnosis. We can have differential diagnosis, and she discussed that, but she is not qualified to make differential etiology. And that is what we're talking about here. We're not talking about a diagnosis, we're talking about causation and etiology. And time again, she said she does not know anything about it. For that reason, we will ask the court not to allow her to testify regarding causation, and particularly what are the causes of retinal hemorrhage. She certainly can recognize a retinal hemorrhage on a picture, certainly describe what it is, but what is the cause of it, she has provided zero evidence in support of her opinion. The state has a burden by clear and convincing evidence to provide data, evidence that her testimony is reliable. The state has failed to do so. Under Dober v. Kelly, 824 Southwest 2nd at 572, these and 573, Judge. The relevance attached to the reliability inquiry require that the background must fit a fact of consequence. The fact of consequence here is etiology. Her background does not fit that at all. Her testimony is supposed to fit a fact of consequence. Her testimony today clearly indicates she cannot do that. Her opinions are fairly conclusory, speculative, and they are not relevant because they are not based on any fact or data related to the field we are talking about. And for this reason, we would ask the court to limit our testimony and to exclude any opinion regarding causation.
Thank you, Mr. McCarthy. Any response?
Thank you, Your Honor. First, my understanding, excuse me, first, it's my understanding that the legal standard is preponderance of the evidence, not clear and convincing, but I just offer that as my understanding. The court might recall, actually yesterday, I commented, or the day before, that about the hearing on Dr. Monson, and he made the comment that the court had made the correct decision, and I commented that I had gotten in my objections. And one of my two objections was pretty much this objection of Mr. Shelley. I talked about fit. I did not question him as long as Mr. Shelley did, but it was clear, and Dr. Monson admitted, that there were many factual, technical, scientific, medical, however you want to put it, facts of this case that he did not know about. But Mr. Monson is an expert as a biomechanical engineer, and by having done experiments, clinical experiments or laboratory or whatever these apparati are, he's done these experiments related to shortfall. And so he was qualified to offer an opinion based on that. And not that it matters, but Your Honor will remember that I said you made the correct decision. And so shortfall has not become the gold standard. Roerich has shook things up, but Roerich has not changed the world. Roerich is going to come in under criticism, I think we can all anticipate, in legal circles and other circles. And I don't know what wins out. And I would imagine that what happens is what's in effect was happening or should have been happening or could have been happening in the original trial of this case was a shortfall theory of defense versus the point of view of the theory, if you want to call it that. I mean, it had been the gold standard and it has not been toppled. It's been criticized, questioned, modified by some, etc., and attacked, as we saw yesterday, by some. It has not been toppled. Shaken baby syndrome, or however, it's still there as a theory. It can be the state's theory of the case. In the same way that shortfall can and will be the defensive theory. And an expert has been qualified properly, as I said, Dr. Monson, to talk about that. So Dr. Monson doesn't know anything about, well, I don't know if he doesn't know anything, Dr. Monson doesn't pretend to know very much about ophthalmology. Dr. Monson doesn't even know anything about the ophthalmological facts of this case, which is one thing that was brought up in the hearings, that he didn't really know the case deeply. He's talking about a defensive theory that has some scientific backing in the literature, and that's fine. They've got a theory of defense, so great. I think I would just be getting long-winded. To me, it's obvious. If Your Honor has a concern, a question, wants to ask me how I can reason something out that you feel doubtful about, Your Honor, of course, I'm at your service. To me, it's obvious that this is qualified expert witness. So you're not impressed?
And I may quickly respond, Judge. It will be very short, and I apologize. I have not heard anything regarding any of the prong under Dober qualification, the two-step inquiry. Does the expert have sufficient background in the particular field? Does then the fit test apply to that background? I have not heard anything about reliability, which is, by the way, required to be shown by clear and convincing evidence. That is Dobert. For scientific and hard science, 3 criteria must be met: whether or not the theory applying the technique applying the theory is valid, whether or not the underlying scientific theory is valid, and was the technique properly applied. Dr. Radinovich, in each time, has stated and testified, she does not know. That is clear. I understood the argument of the state, said, well, since you got Dr. Manson, I should be getting Dr. Radinovich. No. Well, I am arguing so.
That wasn't meant to be the argument.
The
argument was meant to be.
Dr. Monson, and I will.
It's your turn, sir.
Hold on, Mr. McCarthy.
Yes, sir. I beg your pardon. I beg your pardon. I beg your pardon, Mr. Shelley.
Mr. Shelley is speaking. Okay, go on, Mr. Shelley.
Thank you. Regarding Dr. Monson, I'm not going to go into it, and I'm not going to make any correction because I don't think it is necessary, Doctor. But the data that have been discussed by Dr. Radinovich regarding causation are zero. The data, the theory discussed by Dr. Radinovich regarding abusing head trauma, the literature are zero. She acknowledged she did not know any of it. And I'm not asking Dr. Radinovich to know everything. I'm asking her to be versed in the specific area in which she will express an opinion, which is whether or not causation is, she understands causation in the context of retinal hemorrhaging. And time again, she has said she does not know. She doesn't know the data. She does not know the literature. She doesn't know the method. She doesn't know the technique when I ask her to apply. So if the state has any testimony that goes to any of the elements regarding 702 and Dober, I am willing to hear them. However, I would remind Mr. McCarthy that he is not a witness. He is not to proffer additional evidence on behalf, because you offered, if you have any question regarding that, this is the area for the expert witness. So
legal questions.
And that's all I have to say, Judge.
All right. Thank you.
Your Honor, Your Honor.
Yeah.
Okay. Okay, regarding the late notice, mistake on my part. I was getting good cooperation with the other doctor. I just want to say, in terms of methodology and, the mistake I may have made that I won't make again, I was able to deal with the other doctors, and we were trying to do the same with Dr. Radinish's office, and it wasn't working. And so we were able to subpoena, and it got out later than I wanted it to, and so forth. Okay, and so I mean, yeah, that okay. So if she didn't look at something, then yes, that's on the lawyer, and I think she's well. I have several things to say. They won't take long. I don't mean to suggest they will take long, but she's obviously brilliant. She can read those papers. She can comment. She can recant. She can modify. She can do all kinds of things.
Oh,
Okay.
thank you, Mr. McCarthy.
No, please, Judge, please allow me this one time. Finish.
You get like 2 minutes because we got to move on to your next witness.
Thank you.
Okay.
Yes, ma'am. Okay, so if you were to disqualify her, Dr. Munson should be disqualified. He doesn't know very much about the case. Number two, if you want to disqualify her, it's wonderful. It's wonderful. This
Mr.
could be the
McCarthy,
end of the case.
you're coming in
It
and
could be
out.
judicial efficiency.
Yeah, Mr. McCarthy, we haven't
Okay,
been
then
able.
let me repeat. Okay, if I came in and out, let me repeat. This might as well be. You might as well be ruling for the jury if you disallow her as an expert witness.
I don't believe that the standard, but okay.
Gentlemen, this is what I think. I do appreciate the fact that the doctor had 2 days notice, and she was able to speak maybe a little more specifically on the facts and the treatment of this child. But in terms of the questions, I understand your concerns, Mr. Shelley, but by the same token, I did note that she promised to bring herself up to speed, so to speak. So this is what I'm going to do. I will qualify her as an expert, but with the proviso that in terms of causation at trial, she cannot go into causation until the defense counsel has had an opportunity to take her on voir dire outside the presence of the jury in regards to all of the questions that were raised today that she was not, Mr. Shelley felt like she couldn't answer. So that at that point, the court is satisfied that she can opine in regarding causation of abusive head trauma as related or based on the retinal hemorrhaging that she testified to. And so that gives her an opportunity and the state to go back to the drawing board so that she can specifically, hopefully prepare herself to be able to answer those questions and make herself aware of what the current state of the literature is, whatever that may be, because I don't know what it is either, on abusive head trauma and shaken baby syndrome. I don't know what the state of that is in terms of the medical literature, not being a doctor. And that's what these experts are going to be able to provide for us. So what all I'm saying is she's qualified. The only thing is, as to causation, you have an ability to see if you can bring her up to speed to the point where defense counsel can take her on voir dire, and then she can convince the court that she has the expertise in that kind of subspecialty, and then opine as to what she thinks if she's able to. So I kind of split the baby. So there you go.
And just for the record, just so I can protect my records,
Sure.
we do not believe that at this point, the state has met their standard. And that also is the reason at this point in time, the state has not met their standard for the 702, and this is why we're here to qualify this expert now. So that's why I'm objecting to the ruling, and I would ask the court to reconsider and to exclude her testimony only and solely based on the specific and narrow point that I made about causation.
Duly noted. Thank you. Thank you, counsel. I appreciate that. All right, Mr. McCarthy, your next witness.
Thank you. Let's see if we can find him. He says he's on. This is Dr. Alejandro Rios Tovar, which that's hyphenated. And he says he's on.
Does he have the right link? I don't see him.
Let's try. He says he's on.
Just as Robert, he is not trying to log on at this moment.
Or the other
Okay.
one.
Thank you, Robert. Oh, he might have been on this morning's, but yeah, it could be. Anything's possible. Yeah.
You might want to send him the link for this afternoon.
And we
Judge, is somebody sending him the link? Because I don't have his email.
I don't have his email either. I'm assuming that it's a state's witness and the state is.
Oh, I have it. I'm sorry. Here, I can forward it. Actually, no, Robert, you better do it. I'll just give you the email. One quick sec. Okay. Okay, Robert, can you hear me?
Yes, do you want to send it? We are on YouTube. I don't know if you want to.
Mr. Vasquez?
Yes,
Yes.
I'm here. Do you want to send
Okay.
it to me in the chat, or do you want to put it over?
Oh, no, sure. That's fine.
Thank you.
Oh, in the chat. Okay. Sorry, where's my? Oh, okay. Here you are. I'm sorry, Mr. Vasquez, I'm pulling.
Mr. Vasquez and Mr. McCarthy, I just emailed Dr. Rios Tarvar. I'm gonna actually give him a quick buzz and see if he got it.
Yes, I know. It's finally is. It's finally. No. Robert, I can't paste it. Can I send it to you by Teams?
I don't know if yes, sir, you can.
How can this be? This was given to you orally.
McCarthy. Mr. McCarthy. I think your paralegal is reaching out to him right now, and she has.
Logging on.
He's logging on right now. I think he froze. Are
Thank
you there?
you.
Don't hear me?
I said thank you. Yeah.
Okay. Okay, Doctor, welcome.
Oh.
Thank you for joining us. Can I get you to raise your right hand, please? You solemnly swear or affirm the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Mr. McCarthy, your witness.
Thank you, Your Honor. Good afternoon, Dr. Rios Tovar. Thank you for coming. Would you please state your full name for the record and spell it for the court reporter, please?
Alejandro Javier Rios Tovar, ALEJANDRO JAVIER RIOS TOVAR.
Thank you, Doctor. Where are you currently employed?
Currently, I am at UT Rio Grande Valley Health System in Harlingen, Texas, Valley Baptist Medical Center.
And did you were you able to send over your CV?
I did recently, and I realized that it's not been up to date to reflect that new job position, which I started about 2 months ago, 3 months ago.
Okay. Let me.
As soon as I'm back home at my home computer, I'll be able to get to that updated CV with that new job reflection.
Okay. Your Honor, with my computer problems, I requested the CV and so on, and like I'm not able to do what you can normally do with a computer, like transfer back into my email right now, to be honest.
Judge, you're
Let me
muted,
put,
Judge.
may I put Madison on and see if she got the CV? She's here somewhere, I think.
Okay, Mr. McCarthy, don't worry about it. You can send it later.
Yes, ma'am.
Okay, let's just.
Yes, ma'am.
Let's
Yes, ma'am. Dr. Rios. So would you tell me, sir, kind of, without embellishment, just what you would say maybe are the maybe 6 key points on your resume in terms of your experience. Well, first of all, you are a surgeon. That's correct.
Yes, I'm a trauma surgeon specializing in surgical critical care.
Exactly, a trauma surgeon, right? Okay, so at your leisure, but concisely, what you would say would be the key points. If I were asking, if I were saying you have a few minutes to tell me why I want to employ you, what are the key points? Background.
So I graduated from Columbia University with a bachelor's in science and biomedical engineering. I was there from 2003 to 2007. Following that, I went to medical school from 2007 to 2011 at the University of Texas Health Science Center in San Antonio, Texas. Followed that, I did my 5 years of general surgery residency in El Paso at Texas Tech University Health Sciences Center in El Paso, and graduated in 2016 for 5 years of general surgery residency. Following that, I did 1 year of surgical critical care fellowship from 2016 to 2017 with 1 year of surgical critical care. Afterwards, I returned to El Paso at Texas Tech University Health Sciences Center as the Associate Trauma Medical Director for University Medical Center of El Paso, as an Assistant Professor of Surgery at Texas Tech from 2017 until 2022. I took my board exams for general surgery boards earlier this year in March of 2024, where I passed my board exams in general surgery, followed by my board exams in surgical critical care earlier this year in September, for which I passed those board exams as well. So I'm board certified in general surgery as well as surgical critical care. After leaving El Paso, I did 2 years of locum tenens traveling, where I moved down to South Texas to be with family. And during that time frame, I traveled to El Paso to do some relief physician work to help the hospital, which I left while they looked for a replacement for me. And now I am an assistant professor of surgery and surgical critical care at University of Texas, Rio Grande Valley in Harlingen, Texas. I've been there for about 3 months.
Good. Now, you're familiar with a number of the medical issues involving the injuries that were sustained by the child. In this case, her name is Emery Rodriguez. On or about August 29 of 2020.
I am familiar with, after doing some chart review, I was the attending faculty surgeon that saw the patient in the emergency department and was supervising the resident surgeons that were assisting with management of the care.
That made you, in terms of the trauma, unit, that made you, well, you were the ultimate decision maker when you were on duty.
I was the responsible
right?
Physician for that patient's care. Correct.
Thank you. I just want to go over a couple of the injuries and that you observed. For starters, and I guess I would start with the bleeding inside the skull, which, as I understand, images were taken on the 29th, and then on August 31, when she was still in the hospital, the baby. And did you see blood? I don't know whether to say inside the brain or inside the skull, but did you observe blood in those images where, when, and where it should not be?
Yes, but initially there was a skull X-ray that was obtained that showed a parietal skull fracture. An X-ray won't show any blood. Um, when I had seen the patient, my documentation reflects that if there was a skull fracture, to continue with further imaging, which was done later that evening. I don't recall seeing those images until after a day. After those images were obtained, we did see from the radiologist report that there was traumatic brain injury, specifically a subdural hematoma.
And did you also see and determine for yourself that there was a broken, or I guess a fracture to the 8th posterior rib approximately 2 weeks later, after the baby was released?
Sure. So there was a fracture to the 8th rib that was noted on imaging that was obtained 2 weeks after discharge from the hospital. I was not aware of those fractures during the time of the patient's hospitalization.
During the hospitalization, you were not aware, correct?
Correct.
Yes. But you were able to see those images later,
I was.
and of course, as I think you know, we will have a radiologist testifying, but you also know how to read these images as a board certified trauma surgeon and critical care surgeon, correct?
I'm able to interpret the basics of radiologic images, yes, but again, for these images, I rely heavily on the radiologists, specifically the pediatric radiologists, to assist with interpretation.
But you do make your own determination as well. What I mean to say, you don't just accept that; you look for yourself.
Definitely.
And in fact, you were kind enough to try to teach me a little bit a few weeks ago, if you recall. And do you recall that we actually looked at the radiograph with respect to the rib?
Yeah, so there was a skeletal survey, which was performed during the patient's hospitalization to look for any fractures that were new or remote. Typically, a second skeletal survey is performed about 14 days later to ensure that there was no missed injuries during the first survey. During that survey, 2 weeks later, there was noted a right posterior 8th rib fracture noted by the radiologist. And when I reviewed those images, I did see the fracture that the radiologist was referring to. When I returned to the original images that were done during the hospitalization and looked more closely, I can see where the fracture could have been missed by the prior radiologist. And in fact, I believe the documentation of the second radiologist said so.
And if you please repeat the last part of what you said excuse me, doctor. You said when you then looked, I guess you're saying, like after our conversation, you looked again at maybe like better, I mean, better images of the same image. Is that right?
Well, I was looking in hindsight at the specific rib in question. That was clearly fractured on the second set. And when reviewing the first set of images, that is those during hospitalization, I would see with bias, knowing that there's a fracture there, that there was a fracture there on the original images.
Correct. And when you talk about the two images, would those images, I'm sorry, were they taken? We're talking about the skeletal images.
Skeletal survey, correct.
I beg your pardon. The skeletal survey, were those taken respectively on the 29th of August and the 31st of August?
I don't recall the dates. It would not be 2 days apart. It would have been likely the 30th or 31st of August for the first images, and then 2 weeks later.
Okay, right. And correct me if I'm wrong. Did you tell me, and I'm talking about the skeletal surveys now,
Yes.
to be clear, that one set of images was superior because, as I understood it, it was a longer image. It was I don't know how to put it, as opposed to a snapshot versus put it on 1 minute and take the photo, and
No,
that ends up giving you a better image.
No, that's not the case.
If we could not have leading question, I didn't want to object, but there's been
I
a
don't
number
think-
of leading questions, so my objection would be leading.
What's sauce for the goose? And if I'm wrong, I'm wrong, and I'll stop with anything that's close to leading. I thought we were not. I thought these hearings subject to strict rules of evidence, or are these pretrial hearings? I mean, I honestly don't know.
Hold on, Mr. When an objection is made, I'll appreciate a legal response, not a speaking response. And we need to, all of us, not step on top of each other so that the court reporter can take down the ruling. And I'm going to overrule it this time.
Thank you, Judge.
Well,
May I answer, or
No, may
can
I
we clarify that?
Yes, precisely. I have to rephrase. So there was a skeletal survey done on or about the time of the admission of the baby to the trauma unit. And then there was another skeletal survey done approximately 2 weeks later. Is that correct?
Correct. That's correct.
And the skeletal survey done 2 weeks later did you want to make an objection? Judge, I violated your rule. Sorry. I understand.
question and answer. If there's an objection, then you can stop. But let's just get question and answer.
Okay, well, I thought I was hearing an objection.
The skeletal surveys are both done with the same technique. As far as I understand, there's no difference in the technique between the two skeletal surveys. There may be a different technologist, X-ray technologist, technician, but the clarity should be relatively equal between the two images, even if they are 2 weeks apart. The
So,
reason we have a second survey is that there are some fractures, especially in children, which can be subtle and missed by one radiologist, or many, that will show signs of healing on the second image 2 weeks later. And to my understanding, the second image 2 weeks later showed signs that there was healing of that second rib, of that second, on that second image. That is the right posterior rib fracture, showing signs of healing.
Judge, just for the record, if I may, is Dr. Rios Tovar testifying as a fact witness, or is he testifying as an expert witness? Because I'm objecting to that line of questioning. We are talking about the fact of the case. We're not talking at all about any of the double factor to qualify Dr. Rios Tovar.
Yeah, and then that I assumed, but Mr. McCarthy can educate me, that Dr. Rios Tovar is a fact witness, that he also wants him to testify as an expert. So therefore, we really
Honor,
we just
would you like-
need qualifications, reliability, opinion, and the science underlying the opinion, and the relevance. That's all we need.
I understand that, Judge. I believe I think my point is that as a trauma surgeon, he is qualified to look at a radiological survey and make an expert observation on what he sees. To that extent, I was talking about the ribs. Now, because we had so much, I'm addressing the court, since we had significant, detailed, well, I'm saying I'm not going to go, although he will talk factually about what he observed in the ophthalmological, I wasn't even going to go into that. I'm trying to streamline. I just was going to cover the things that, should be covered so that I can make sure that he could testify on them. And honestly, if the court would give me a little leeway, even from the point of view of Mr. Shelley, this witness might be very short.
I'd like to have a better understanding of what opinion he's going to offer. I don't need to know about the injuries so much as the opinion and what's the basis of the science of the opinion. I pretty much understand the relevance.
Okay. Yes, ma'am.
Thank you.
I think I understand. Dr. Rios Tovar, with respect to observations, determinations, decisions that you made regarding the treatment of Emery Rodriguez, can you explain to the court what is the factual basis of those opinions, determinations, etc.? What are the factual bases for them? What data did you use? What did you use?
So,
I'm going to ask to confusing because, and I'm not sure I understand the opinion that is trying to elicit because it's vague as to if
Mr. Shaw, I'm over right now. I'm hoping that he's going to develop it. I share this. I'm confused as well, but I'm going to give Mr. McCarthy some time so we can understand. So thank you.
Thank you, John.
May I proceed?
Please.
So as a trauma surgeon at University Medical Center, I am responsible for caring for patients, young and old. We have a set of guidelines in our hospital policy with regards to specific fractures, specific injury types, whether it's involving patients with gunshot wounds, patients who
Judge,
fell
I hate
from
to
standing.
interrupt, but I think we lost our court reporter.
Hold on. Sorry, doctor. We can't do any of this without a court reporter, and I apologize. If she dropped out, she'll come back in. So you get a little bit of a respite.
I understand.
Yeah, it feels like we're fighting the technology every day, but it is what it is. So I don't know what to tell you. So
Okay.
20 years from
May I
now.
address the card?
Yeah. Yes. We don't have a court reporter right now, so nothing's on the record.
Fine. This does not need to be of record.
Okay.
My understanding of the court's suggestion or instruction just recently made was that the court wanted the underlying facts or data. That was the basis for that question. Okay.
No.
And so what I was trying to do was to, in fact, follow those rules. And I understood the court wanted to know about reliability of the underlying body of knowledge or science.
Yeah.
Or,
The factual basis is not, I don't think
the
this
area of expertise, because
Yeah.
medicine seems to be under attack these days.
I don't know about that, but I don't know that the facts. I'm assuming you're wanting this witness to opine. So if you're going to have him opine in terms of
No,
what's the crux of the matter, which is the causation, which is fine, but I just need to understand his qualifications to do that, and I do have a sense of his qualifications, but his qualifications to opine on that particular subspecialty, and possibly, and I think he was trying to explain that before the court reporter dropped out on us. And I think the other thing was just talk about the reliability of the science. But hopefully here comes
okay, I understand.
Yeah, here comes our court reporter. And I think Dr. Rios Tovar is trying to do that right now if we can let him answer.
Judge,
Yeah.
I lost you all.
I know it. That's fine. We waited for you. We're not going anywhere without
I'm
you.
sorry, Judge. Okay, the last thing that Mr. McCarthy said was, I understand that, Judge. I think so. My point is that as a trauma surgeon, he is qualified to look, and then I was gone. I really apologize.
Oh, no, that's fine. Where would you like to pick up, Mr. McCarthy?
Thank you, Judge. I'm going to pick up where I think you would like me to pick up. And that would be to say, Dr. Rios Tovar, can you explain or describe to the court we already know about your educational background. Can you explain how do you become board certified in these two specialities of trauma surgery and critical care?
Hold on, Mr. McCarthy. I think Dr. Rios Tovar has already explained he's board certified. And
okay, I guess I'm missing the point. Then I guess I'll get to what the next point is.
I just don't understand. He's going to be a fact witness.
It's medicine,
right? He's going to be a fact witness, what is he going to opine on as an expert?
If the court will indulge me, no, if you just indulge me,
Sure.
something that's not
Sure, no.
completely open-ended. My understanding, doctor, is that you will, or opine, or however you want to put it, conclude that there was I'll make it very colloquial. There was a very serious skull fracture to the baby. Is that correct?
Yes. So if I may speak freely,
Sure.
um,
Please.
I have been at UMC and Texas Tech for over 10 years, 5 during my years of training as a general surgery resident. During my time there, I spent a majority of the time treating patients in a trauma setting. Like I said, gunshot wounds, motor vehicle collisions, motorcycles, or simple falls. Elderly people had fallen, certainly children who had been bitten by dogs or fallen as well. And as a faculty member, in my subsequent 5 years, I was the supervising physician for those residents who were in training as well. And we admit at UMC up to 4,000 trauma admissions per year. As the only level 1 trauma center in a 250-mile radius, we get a majority of our patients, actually about 40% of our patients from southern New Mexico transferred in. During this time, we developed guidelines to treat various injury patterns, whether it's a splenic injury, whether it's a traumatic brain injury, whether it's an open fracture after a motorcycle collision, whether it's a pediatric patient who sustained a fall or maybe even a motor vehicle collision. And these guidelines, although they are not set in stone, as in you must follow every single word on this document, they are at the University Medical Center to assist with making sure we have a standardized level of care for each patient, no matter what injury pattern they develop. One of our guidelines is a non-accidental trauma guideline, or NAT guideline. That involves imaging studies that we obtain on certain patients of various ages, whether they're below 2 years of age, below the years 5 years of age, or whatnot. And there are certain red flags that are in our guidelines that prompt further evaluation, whether it's with a skeletal survey, whether it's with further imaging with regards to an MRI, whether we involve social worker case management to see if this is something that is a non-accidental trauma, a trauma that is not accidental, not saying that it's something that's in disagreement with the history that is obtained given by the care provider. Some of these red flags include remote injuries, injuries of various ages, certain skeletal injury patterns, certain things such as bite marks, certain things such as changing history. And based on these guidelines, which we followed, or which we tried to follow for each patient to make sure that we have standardized care for each patient, there's the guidelines that I followed for this patient as well as all other patients. Now, in this regard, we enlist the assistance of our pediatric radiologists. We enlist the assistance of our pediatric or our ophthalmologists, as well as a CARES team, which I can't recall the acronym at this time, but just to ensure that we have a safe discharge for all of our patients, even those which have a simple fall from a changing table, for example, sustain a skull fracture without any other types of injuries, making sure that we have an appropriate and safe discharge home from the hospital with the appropriate follow-up. And so in that regard, we noted some inconsistencies, not necessarily all at the time of admission, but at the time afterwards, where we noted that there was some abnormal x-rays that were done 2 weeks later that were not seen on the initial x-rays. And so we do see pediatric patients on a daily basis. While I'm at UMC, I see patients like this pretty much on a daily basis, and it's a team effort to ensure that we have the appropriate level of care for each patient. I'm not sure if that answers your question in terms of my role and the role of the different members of the team.
Thank you very much for that answer. That answer, I mean, the judge also certainly wants to know what you're going to be making conclusions on. So that answers a really good background, because I had meant to talk to you about those protocols or policies or guidelines that are set up by the hospitals and so on. And I think you did it much better. So with respect to conclusions or opinions, as an expert trauma physician and critical care trauma surgeon, I'm sorry, and critical care, two board specialties, you did see and concluded there was a skull fracture. Is that correct?
Correct. That's correct.
You did see and conclude that there's blood in the brain or blood in the skull that shouldn't be there. It's abnormal.
The brain and the skull is considered a subdural hematoma, and that was found on MRI study. Correct.
And you also concluded by your own examination and re-examination that there had been a fracture to the child of the eighth posterior rib.
That was not something that I was aware of during that patient's hospitalization. It came to my attention afterwards because it was discovered on the x-rays 2 weeks later.
Okay, so to be clear, nevertheless, you looked at that skeletal survey.
Yes,
right?
But I am aware that there is a posterior right eighth rib fracture. Correct.
And in fact, you looked at that skeletal survey with me as a teaching tool, right?
Correct.
And then, so you've looked at it very recently. And if I recall, you confirmed and concluded of your own opinion that it was a fractured rib.
Leading judge, if you could just ask him what is his opinion instead of telling him what is his opinion.
Judge, I was only trying to distinguish from the fact of relying on a radiologist. I'm trying to ask him, irrespective of what any radiologist may have said about that, you looking closely at that radiograph, if that's what it's called, did you determine of your own opinion that there was a fractured rib?
So I determined that after reviewing the second image 2 weeks later, after looking at the second image of the same chest x-ray, a second chest x-ray of the same patient 2 weeks later, I then went back to the original chest x-ray done during the original skeletal survey, which was read by a radiologist at that time as normal, apart from the known skull fracture. And at that time, they did not declare that there was a rib fracture on that initial skeletal x-ray. But again, I was able to see that x-ray. I was able to see the rib fracture that was in question noted on the second X-ray series 2 weeks later. Again, perhaps with that bias that I was looking directly at that spot, and I was not able to see that on my initial review while the patient was in the hospital.
Okay. And I guess I should ask you, and let's keep this brief because we had a lot of testimony on this. And just to be clear, did you also have occasion to review the ophthalmological images regarding the retinal injury?
I don't recall seeing the images themselves. I do recall reviewing the report from the ophthalmologist of their examination.
Doctor, was there, we've glossed over things a lot, but beyond those things that we just touched on as injuries that you directly observed and concluded, were there any other injuries to the child that
Sure. So
you yourself found and concluded were injuries of note?
reviewing the documentation, we were made aware of a left retinal hemorrhage. I cannot recall if there was a right retinal hemorrhage as well. And I don't recall the specifics off the top of my head without reviewing the chart. Retinal hemorrhage is something that can occur with a variety of injury types, but the most common cause of a retinal hemorrhage is NAT, or non-accidental trauma. I'm made aware that there are other subtypes, there are other certain instances where a retinal hemorrhage can occur, but those I would have to defer to an ophthalmologist.
Okay. In our discussions, well, you testified in this case, well, excuse me. In the original trial of this case, approximately last June, you were qualified as an expert witness, correct?
I don't recall the specifics. I believe that's correct.
Do you recall, in fact, testifying before the jury?
Honestly, I don't recall that specifics of the day. If there was some sort of recording of it, it would be beneficial to me to help me recall, or even if there's a court reporter that can give me the specifics of that, I would help me with jogging my memory.
Yes, we have 45 or 50 minutes of Mr. Shelley cross-examining you, and we'll provide that to you.
Honestly, I don't recall that. I apologize.
Sir, you're kind of a busy man, aren't you?
Yes, you could say that. I'm sure we're all busy.
Now, at the trial, and you, or in any document, or in our conversations, have you ever given a conclusion as to the cause of the injuries?
I don't recall, but based on the information that I have currently, I can give a conclusion based on the information that I have now.
You can give a conclusion now as to the cause of the injuries?
I can give a conclusion as to what could not have caused the injuries. Let me rephrase.
Thank you. Doctor, either take it as you want. I don't know how many of these there are. Either the list or explain each one in your own time. What could not have caused the injuries?
In my opinion, based on the history and physical, the HPI, the history of present illness that was documented by my team, as well as the history and physical and HPI documented by the pediatrician on admission to the hospital. What I recall is that there was a history given that a 3-year-old or 2-year-old sibling, a 2 or 3-year-old sibling was carrying the patient and had dropped the patient from a height of about 2 feet. This was a 5-month-old patient, and that the patient was with some abnormal respirations on the scene. But by the time they arrived to the emergency department, they were acting appropriate and breathing normally without the assistance of oxygen. Based on that, with the location of the subdural, where the traumatic brain injury being on the left side, and the fact that there is a posterior rib fracture that was known later on the right side, these 2 injuries could not have been sustained by a fall of 2 feet, whether they're being carried in the arms of a 2 or 3-year-old sibling or another fall of that height. So the history that was given to us at that time did not match the injury pattern that we observed based on imaging studies.
Is there anything else that could not have caused the injuries? Well, I mean, so there's a million things, but I meant, sorry, doctor, I'll rephrase. In terms of ways that you know of that can commonly cause such injuries, were there any others that you ruled out besides the ones that you just mentioned?
Not sure I understand the question. I know in my experience, like I said, there are different ways that patients present to us: gunshot wounds, stab wounds, motor vehicle collisions. I can rule those out as a cause of this injury.
Okay. Or any kind of well, I withdraw the question because it's never been in evidence. Doctor, thank you very much for your lucidity and your help, and I pass the witness.
Thank you. You talked about guideline, Dr. Riostovas. Who wrote the guideline regarding non-accidental trauma?
These are guidelines that are part of University Medical Center and were written in combination with our trauma medical director at the time, our trauma program manager, and these are updated every 3 years. They're reviewed with regards to the literature at that time. There are references for each guideline that we use, and specifically, the most recent copy that I have is from 2021, I believe. And so I would expect that they are on the verge of updating those guidelines, or at least reviewing them to see if they require update. They're based on the American College of Surgeons website for, among others, for non-accidental trauma in pediatric patients.
And Judge, saw Mr. McCarthy leave, so I don't know if the court wants me to continue without him being present. And he's back.
No. Not at all. I didn't hear you, Mr. Shelley. Sorry, I received an inquiry. I beg your pardon. Yes, sir. Am I
Just
on?
to,
Yeah, I'm
just
sorry.
to
Yes, Mr. Shelley.
recap,
No.
Oh, no. On the guidelines and so forth, that's one of the few things I do understand. Please, go ahead.
Thank you. You did not follow the guidelines when the child presented to the hospital, did you?
there were some deviations from the guidelines, correct?
And you talked, I want to talk to you a little bit about, well, actually, one of the things we talked about during the trial. I'll start there. We're going to talk about shaking baby syndrome and controversy in the literature. I don't know if you recall, but when you testified at the first trial, I asked you whether or not you were aware there is a controversy regarding the diagnosis of shaking baby syndrome. Do you recall that question?
Do you recall that question, actually? Yes.
Recall your answer, doctor.
I recall at the time that I was not aware that there was a controversy. Correct me if I'm mistaken in my answer now, but that's what I recall my answer being at the time of the trial.
That is correct. Has that, would that answer be different today, doctor?
That answer would be different today.
Okay. Can you explain to me why it would be different?
I was reading some newer articles and older articles regarding the biomechanics of shaken baby syndrome. But again, shaken baby syndrome is nothing that I would testify towards in this case. Correct me if I'm wrong. If during that trial I made comment on shaken baby syndrome itself, please correct me if I'm mistaken.
And I would, and I'm not implying you did. I just wanted to give you a chance to, because I know I had mentioned that last time. So I wanted to give you a chance to see if you had, being able to look at the literature. And I do appreciate your frankness on this. You said you are not an expert regarding shaken baby syndrome. Is that what I understood, or I don't want to misquote what you said, doctor?
I'm not one that uses the terminology of shaken baby syndrome.
Which
That's not
terminology
something
would you use?
I typically will reserve my terminology for patients who have accidental trauma or non-accidental trauma,
Okay.
which I shorten to NAT.
Okay.
Now that non-accidental trauma is trauma that is not in keeping with the history that is provided when assessing the patient.
Now I want to. You talked a little bit about shortfall when Mr. McCarthy was asking you a question, and you said you would not. At least the presentation of the child is not consistent in your word, I believe, with a shortfall. Am I saying, is that what you said? I don't want to misquote you.
Sure. So a child fall, did I hear you correctly?
Yes. You said, am I correct to believe that you said that the child, if that child had been the subject of a shortfall, it would not be presenting with the symptoms that you saw when he was at the hospital. Is that correct?
Sure. So initially, when the skull fracture and the subdural hematoma were the only injuries noted, that might be present during a fall from a certain height. When it's encountered that there are multiple fractures or multiple injuries of various lateralities, that is less consistent with a fall from whatever height.
Sure. How many fracture have you seen on that child, doctor?
Seeing the posterior rib fracture on the 8th rib is one of our red flags in our non-accidental trauma guidelines, because it can be caused with grasping the child with fingers and a grip around the torso in a manner that is more aggressive than typical. And it's not something that I see in fractures, even in motor vehicle collisions.
Are you talking about the fracture that was not seen when the child presented at the hospital?
I'm referring to the fracture that was seen on the second X-ray survey, skeletal survey, which was present on the X-ray survey on the initial that the radiologist did not identify.
Okay, so that was not seen the first time on the skeletal survey, is that correct?
The radiologist did not report on it. Correct.
So are you saying that the radiologist saw it and didn't report it?
I'm not sure to the specifics, but I doubt that that's what occurred.
Okay. How old was that rib fracture, doctor?
The rib fracture on the that we're talking now about in question,
Yes.
it was old enough to show that there's a callus formation 2 weeks later. So it occurred prior to that secondary skeletal survey.
Okay. Let's talk about shortfall, because you talked about shortfall, and how familiar are you with the science and the literature of shortfalls?
With regards to the literature from the entire spectrum from the 70s, 80s, 90s, and today, is that what you're referring to?
I don't know. I'm referring, what are you familiar with? Are you familiar with, well, you tell me, what do you know about abusive head trauma? Let's start there. Do you know, I don't want to go too wide here. So let's start with this. Are you familiar with instance of children falling from a short distance and exhibiting subdural hematoma, retinal hemorrhage? You're familiar with that, right?
Yes.
Okay. And so you could see the same injuries here on a short fall that you see with that chart regarding retinal hemorrhaging and subdural hematoma.
If there's multiple injuries of multiple time frames, then that would not be explained by a single fall.
Did you see injuries on the skull from multiple time frame, doctor?
I don't recall.
Okay.
I was led to believe that there were multiple lengths of time that there were seen different types of blood, but I'd like to review the chart to ensure that I'm not speaking on a different case. Will we be able to see those images together?
Sure. But we won't be doing that today. I want to ask you if you're familiar with, this is a difficult I'm having here. I'm trying to understand, you talked about these guidelines, and I'm trying to narrow down, what are these guidelines based upon? Because you talk about guideline, it was written by your trauma surgeon. They are written based on what?
Based on the evidence and the references in each guideline, I can
What
pull
is the
those up.
evidence?
Specifically, the American College of Surgeons, I believe it's TQIP, the Trauma Quality Improvement Program.
Okay, and the guideline, well, you said they were not followed in this case, some of the guideline. What I believe that a child who was, you believe that the only explanation for the injury you saw is non-accidental trauma?
I believe so.
Okay, can you explain to me exactly why and what it is about these injuries specifically that are only possible in a non-accidental trauma?
The fact that the history was not consistent with the mechanism of injury.
What history is not consistent, doctor?
The history that I reviewed and that I recall was that the child fell of 2 feet height from the arms of a 2-year-old. Correct me if I'm mistaken in that history.
Okay, so are you saying that you cannot see subdural hematoma and retinal hemorrhage from a fall of 2 feet, doctor?
I'm saying that you can, but I'm saying that you cannot have a right posterior rib fracture at the same time as that.
So you believe the rib injury, it occurred at the same time?
The fracture is present on the initial skeletal survey. I can't speak as to why the radiologist didn't declare that it was there.
Yes, but my question is, do you know whether or not the fracture of the rib was occur at the same time as a fall?
It was in the imaging obtained during the skeletal survey during the fall, hospitalization for the fall.
I understand, doctor, but my question is a little bit more specific. Do you believe that the rib fracture occur at the same time as the injury that caused the subdural hematoma and the retinal hemorrhage?
I don't know the answer to that.
Okay. So if you don't know the answer to that, let's focus then on subdural hematoma and the retinal hemorrhage. These two findings, if you have that, are you going to conclude that the child is non-accidental trauma?
Even more so.
Okay, explain that to me. Tell me what is the basis of your opinion that subdural hematoma and retinal hemorrhage are not consistent with a shortfall?
I didn't say that.
Literature in support of that, please, doctor.
I did not say that. I'm saying that if you're arguing that the rib fracture was present prior to the same day of the subdural hematoma, that would give me even more concern that there was a non-accidental trauma, that the child was abused by grasping the child's chest and having an earlier rib fracture and then having a subdural hematoma from another fall. So there's multiple injuries on multiple dates.
Multiple injuries on multiple dates. So then again, my question is
on your theory.
Yes, doctor, I'm talking about specifically, assume with me for a second that you have a shortfall incident. Okay?
Yes.
Would you see subdural hematoma and retinal hemorrhaging on a shortfall incident?
You can.
Is that possible?
You can, yes.
Okay. And there is literature in support of that, correct?
Yes.
Okay. So are you telling me that the reason you believe it is a non-accidental injury is because you have that rib fracture in addition to the subdural hematoma and retinal hemorrhaging?
That is part of it, correct?
So if it was not a rib fracture, that would indicate more likely that it's very possible you had a shortfall incident.
It's a possibility, but
Okay.
given the entirety of the facts, that's why I draw my conclusion as I did.
So you're telling me the fracture is the rib fracture is a critical element in your decision making for non-abusive, non-accidental trauma?
This, along with the retinal hemorrhage, as I defer to an ophthalmologist for their expertise.
Yes, but if I make it clear, you just told us that if you only had subdural hematoma and retinal hemorrhage, you would consider a shortfall. However, if you add the rib fracture, then that's take it out of the window.
It's a big part of it, yes.
Okay.
Like I said, I agree with you that there is literature that a shortfall can occur and there can occur a subdural hematoma with a retinal hemorrhage. That's in 4% of cases as compared to 76% of cases with non-accidental trauma.
Can you tell me what is where do you get these numbers? What is the source of these numbers, please?
Yes, I have it in my computer. If I can minimize this,
Sure.
if you will allow me. Thank you.
I can be minimized.
Excuse me. I may. Would I be able to send you our guidelines, or do you have those present?
You do have them, Mr. Shelley. I sent them to you, but I don't know if you can access them.
Oh, I'm sorry, I was muted. If you can just read, Doctor, the literature in support of the number you gave me, that will be sufficient.
Sure. I don't have those with me. I have several bookmarks. It would take much of the court's time. I would like to send those to you when I have the ability to track that down. And if I'm unable to, I can retract that statement.
No, that's fine. You can send them to me later. I don't have a problem. Just quickly, the rib fracture. What kind of force is needed to fracture a rib of an infant?
Ribs generally don't fracture in major forces with pediatric patients. We'll see patients with car accidents who have no rib fractures at all, but have an underlying pulmonary contusion because the ribs are very malleable, pliable, if you will. To have a single rib fracture, especially posteriorly, is something that's pretty unique to a specific force that is from grasping the child, is the theory, with both hands and grasping tightly so that the fingers are putting pressure on the posterior rib at the costovertebral angle junction.
Okay. And
So,
that's, I'm sorry, you want to finish, Doctor?
so I don't know the specific forces that are needed to produce that, but it is forces that are applied directly to a single rib or multiple adjacent ribs. That is a different mechanism than you would see in an adult patient with multiple rib fractures who have already had time to develop.
Would well, let me ask you this, Doctor. If a child is, let's say, on a table, and I'm holding the child down, would I be able to cause this rib fracture?
Can you describe
Yes, and I
the method, please?
yes. If this is a table and I
Okay.
am standing up, Judge, and I'm using my right hand to provide a horizontal plane, and you have a child on the horizontal plane, my hand being a table, and you hold
Okay.
that this way, would I
Okay.
be able to cause that fracture, Doctor?
If you're applying a certain force with your fingertips, that's the theory that is the rib fracture can occur in posterior orientation.
All right. Thank you very much. If I can have 1 second, Judge. So, and just to be clear, because this is an important point, and I know I may have asked you, but I'm going to ask you again so that I don't want to put word into your mouth, Doctor. The child presents just subdural hematoma, retinal hemorrhaging. You could conclude that is consistent with a short fall.
Taken alone
Yes,
without
all
any
things being equal.
without any further history.
That's correct.
I don't make those judgments without an entire picture.
Okay,
There are
so tell me,
multiple.
so a child who presents with subdural hematoma, you receive a child, you see a subdural hematoma, and you have retinal hemorrhaging, and obviously the child doesn't speak, you don't have parents. What are you going to conclude is the cause of injury?
I don't make a conclusion based on that information alone.
Okay. But if in addition to that, you have an A3 fracture, that is non-accidental trauma.
It is more consistent with non-accidental trauma than not.
Okay. What consistent means? That means, are you talking about causation? Are you talking about correlation?
There's a higher index of suspicion for non-accidental trauma, which will then lead to further investigation.
What is the index? What are the level of index and what are they based on, Doctor?
I'm sorry, I didn't understand the phrasing.
Yeah, I'm sorry. You said there is a higher index of suspicion. I'm trying to understand what index we're talking about.
Sure. So a higher suspicion for non-accidental trauma when we have patients who have a posterior rib fracture, injuries of various ages, a history that's not consistent with the injury pattern. For example, there's a longer list in terms of red flags.
Now, just you have that skeletal survey on August 30, 20 that is done, and I want you to consider that presentation at the time as the child comes in. At that time, the data you have is subdural hematoma, retinal hemorrhaging, and the skeletal survey indicates no rib fracture.
That's correct.
That is the presentation on the 30th of August. Is it possible that you have non-accidental trauma at that presentation, doctor?
When I hear that the patient had a 2-year-old brother carrying a 5-month-old, that was concerning to me when the history. That seemed out of place in my experience.
What experience do you have with children carrying other children, doctor?
I have a 5-month-old, and I would not allow anyone to carry my child during that first month of life, other than myself and my wife, and perhaps a responsible adult. That's the experience that I have personally.
I understand that. And I'm not trying to get off track here, but obviously your experience is not everyone's experience. It is possible for a child to pick up a child. That happens.
I hear a phone or something, phone call, or I don't
Not
know.
my screen.
Okay, I'm sorry. Sorry, Mr. Shelley.
That's okay. So you knowing what you know, you have if the information you have, doctor, is that a child is picking up another child, the child is about 2 feet, and the fall, that child drops the child from about a height of 2 feet. You see the presentation you have, subdural hematoma, retinal hemorrhaging, and that's all you see. That presentation to you would not be consistent with accidental trauma.
That history, in my experience, does not seem appropriate, and so they would be a red flag for me.
Okay, and I'm trying to
And again,
understand.
that's my personal experience.
Okay, it is bad, but okay. So, is there literature telling you, okay, on this set of facts, you should not, or you should consider non-accidental trauma?
No, the literature says that there's a various history of there's different history presented, or if the history presented is not consistent with the injury mechanism, or if the history presented is a delayed presentation, if the history is seems consistent with um, appropriate care of the child, those are also red flags.
My question is far more narrow than this, doctor, and I apologize if I keep asking you. But this is the hypothetical we are dealing with here. You have a presentation. The history is you have a child who picks up another child. The child then falls about a short fall distance, about 2 feet. The child presents with subdural hematoma and retinal hemorrhaging. This is a history you have, and this is a symptom you see, and this is the injury you see. Is this consistent with accidental trauma? Yes or no?
I think it's neglect. If you're going to have a 2-year-old take care of a 5-week-old, that's neglect. And I'd rather not go into that. I'm trying to stay with the facts here.
And I'm giving you an hypothetical with the following fact. I'm not asking you if you have a case of neglect. I'm asking you is on a short fall from a distance of 2 feet, and you see subdural hematoma and retinal hemorrhage, can you have an accidental trauma? Or does it have to be non-accidental? That's all I'm asking you. I'm not asking you anything else.
So in that particular case, which is not the case that we're describing today, that would be a non-accident, not necessarily an accidental trauma. But again, that relieves out all the facts of the case.
And that's why it's an hypothetical, doctor. Thank you. Because okay. Can I have a minute?
Judge, this is Robert. We can't hear you.
Oh,
Yes, Mr. Shelley. Can you hear me now?
if I
Very
have
muted.
Not really, Judge.
oh, can you hear me?
Yes.
Yeah.
Okay. I asked the court if I could have a minute.
Yes.
Thank you, Judge. Just quickly, a couple of questions, Judge. Not Judge, but Doctor. Have you published anything regarding abusive head trauma?
I have not.
Okay. Have you published anything regarding mechanism or causation regarding abusive head trauma?
No,
Have you published anything regarding shortfall?
I have not.
Okay. Have you done any experiment, biomechanic experiment regarding shortfall and abusive head trauma?
In undergraduate school, I did some biomechanics during my biomedical engineering undergraduate education. That was more than 20 years ago. And it's so far behind me, I don't recall the specifics.
If I were to ask you what kind of force is necessary to create a subdural hematoma, you would not be able to answer that question, or would you be able to?
With regards to how many, the force,
Yes.
I would.
Let me ask you a more narrow question because it was maybe too general. Would you know the kind of force generated by a 2 feet fall?
I don't know the specific units. No,
Okay.
a lot of that depends on the the surface of the fall, whether it's carpeted or non-carpeted. There's a lot of aspects to it, but no, I would not be able to discuss that.
Okay. About the witness.
Yes, does. Okay, I know, because I don't see myself or anything. I didn't know if I was even connected. I mean, I see you all, been listening. Thank you. Your Honor, respectfully, the state, with respect to the body of knowledge of medical science, specifically critical care medicine and trauma surgery, we submit Dr. Alejandro Rios Tovar as an expert witness in this cause and move the court to qualify Dr. Rios Tovar as such. And I'll leave it at that. If the court requires further specificity of what we're requesting, I'll be happy to answer.
Well, I would ask exactly what are you offering Dr. Rios Tovas as an expert witness in the field of etiology of abusive head trauma? Are you offering him as an expert witness as a trauma surgeon? Are you offering him as to causation? That's really the only question. I'm a little unclear as to what you're offering him
Thank you,
to
Mr. Shelley.
his opinion.
Thank you, Mr. Shelley. Let me rephrase. I'm offering and moving the court to accept Dr. Alejandro Rios Tovar as an expert witness in the medical science subspecialty of trauma surgery and also of critical care medicine, and to qualify Dr. Rios Tovar to testify as he has today on any and all questions that were put today, as he has today, or as the doctor himself said, to modify if he's convinced he needs to do so.
You're muted, Judge Abi, or we can hear you.
Hear me, sorry.
Now we can.
Thank you. Okay, thank you. Dr. Rios Tovar is admitted as an expert in the trauma surgery and I think it was critical care surgery. But at any rate, all right. Anything further?
Nothing further, Judge.
All right, terrific. Thank you. And Mr. McCarthy, you weren't here, but we were discussing not next week, excuse me. We have a hearing set on your motion for continuance on Monday, the 16th at 1 o'clock.
Thank you, Judge. I think that'll be swell. I got an outcry hearing. I don't know if they conflict. Obviously, this will take precedence.
No.
Thank you.
Let us know. All right. Thank you so much. Everybody have a wonderful weekend. And thank you again, Dr. Rios Tovar, for your time this afternoon. We appreciate it.
Thank you.
Thank you, everyone.
We're adjourned.
And
Thank you, everyone. Thank you, Doctor.
just for the record, I would just ask Miss North if we would be able to get just a transcript of that last, just a ruling on the court. That's it. That's it. Just so we have it for the record.
Judge,
Send me an email, Mr. Shelley.
thank you, Mr. Shelley. Judge.
Yes.
Judge?
Yes.
Did the judge leave?
No, I'm right.
I just don't see her. Your Honor, are you there?
Yes. I'm here.
Okay, I'm sorry. I don't see you. Okay, I'm sorry. Okay. I don't know who to go to if this becomes necessary. I think we've had like a half dozen cart reporters in these hearings, and so how do we collate everything? Were we to decide to do that?
It would be the Council of Judges. The Council of Judges. Can you hear me?
The Council of Judges. Yes, Council of Judges.
Because all the court reporters that we had, none of them are with the 168. If I remember correctly, somebody correct me if I'm wrong, but they're all on assignment from the Council of Judges. And so they'll know, but yeah, y'all are going to have to keep track of the names of the court reporters for every hearing because that's just the way it is.
henceforth. Okay.
Yeah.
Thank
Yeah,
you,
that's-
Judge.
Yeah, all right. And I don't know, we may have these Zoom hearings. I think the Zoom hearings are kept for a certain period of time. So you should be able to track down the court reporters through the Zoom hearings if they are not disposed of. And I don't know that they are, but I don't know what the court's retention policy is on Zoom hearings. So there you go. All right.
On retention for.
Yeah, I don't know what the policy is. All right. Thank you so much for
Thank you.
happy weekend.
Thank you,
Likewise.
Judge.
Bye.
Same to you,
Enjoy
Judge.
your weekend. Bye. Bye, Mr.
Safe
McCarthy.
travels, Judge.
Mm.